Mr. President, I am deeply honored to present my credentials to you today as the United States Ambassador to the Republic of the Philippines. As President Biden emphasized in his call with you on May 10th, America's commitment to the Philippines is deep and enduring as friend, ally, and partner. We are fellow democracies bound by a rich shared history. We share the powerful, positive ties of family embodied in the 4 million Filipino Americans in the United States and the 350,000 U.S. citizens in the Philippines. Our alliance is a bedrock of our bond, and our mutual defense treaty and other agreements are at the heart of our commitment in the United States on all these issues. And I'm also deeply grateful, too, for the friendship you have shown our Deputy Chief of Mission, Heather Barriaba, and all of us at the U.S. Embassy team, even before you took office. With your leadership, we are glad that our bilateral ties are off to an excellent start. Thank you.
Thank you, Madam.
Thank you so much.
Ambassador. Welcome to the Philippines.
Thank you.
Diplomatic correspondence is the official channel of two or more states to communicate to each other and designate diplomats to its country. Another channel to build friendly relation among nations is the creation of treaties. Usually, the treaties was established because disputes happen between the states. Thus, through treaties, the states are able to settle the issues and establish a harmonious communication to other states. A treaty, on the other hand, is a generic term or a term used to designate agreements, generally of a major significance. Treaty has a long been customary term used for international agreements. It is today reserved for reasonable significant acts. Under the umbrella term of treaty, there is also called the term convention. Usually contains general legislative provision but in a less than significant area than treaties. It has become the standard term to designate instruments established under the aegis of international organizations. One of the examples of this convention is the Vienna Convention of Diplomatic Relations of 1961. The Vienna Convention of Diplomatic Relations of 1961 is aimed to establish a foundation for diplomatic relations between governments. The importance of diplomatic ties in global politics was acknowledged, and it was agreed that having a clear rules and regulation in place would help to avoid misunderstandings and confrontations. The protection of diplomatic missions, ability to function, and the assurance that diplomats can discharge their responsibilities without obstruction or harassments are the goals of the Convention's provisions on diplomatic immunity and the inviolability of diplomatic premises and documents. These clauses are founded on the reciprocity concept, according to which each state promises to accord diplomats from other governments the same privileges and immunities. The convention also contains provision on the termination of diplomatic ties. In order to foster international collaboration and understanding and set up a framework for diplomatic relations between states, the Vienna Convention of Diplomatic Relations has been significant. The Vienna Convention of Diplomatic Relations of 1961 lays out the guidelines for diplomatic relations between nations. Since its adoptions in 1961, a sizable number of states have ratified it. The Vienna Convention of Diplomatic Relations of 1961 specified the obligation of sending state and the receiving states, as well as the privileges and immunities accorded to diplomatic agents and their families. It establishes the confidentiality of diplomatic communications and records and it stimulates how diplomatic ties can be broken. Moreover, the convention also specifies the obligations and liabilities of diplomatic agents, including the need to uphold the laws and rules of the host nations and refrain from meddling in internal affairs. It outlines the steps involved in establishing diplomatic ties, such as exchanging diplomatic envoys and negotiating agreements between sending and the receiving states. In Vienna Convention of Diplomatic Relations of 1961, there is a principle of diplomatic immunity, which exempts diplomatic agents from the courts and other authorities of the receiving states, is one of the most significant sections of the convention. The goal of this immunity is to shield ambassadors from intimidation or disruption of their ability to fulfill their duties. All things considered, the Vienna Convention of Diplomatic Relations is essential for fostering friendly and cooperative diplomatic relations between nations. The international treaty known as the Vienna Convention of Diplomatic Relations of 1961 describes the principle and procedures for diplomatic relations among nations. On March 22, 1961, the Vienna Convention of Diplomatic Relations was made available for signature. It became effective on April 24, 1964 after the adoption on April 18, 1961. It has been approved by 193 states as of April 2023. The Vienna Convention of Diplomatic Relations of 1961 established a thorough framework for the conduct of diplomatic relations between states and aided in the promotion of friendly and cooperative ties between countries. It was an important development in the field of international diplomacy. The preamble and the numerous section of the Vienna Convention of Diplomatic Relations set forth the treaty's objective and guiding principles. Some of the main purpose and guiding principles are: the following are the purpose or the principle of the Vienna Convention of Diplomatic Relations of 1961. First, to facilitate the communication and exchange of informations between states. Second, to promote the development of friendly relations between states. Third, to ensure the effective function of diplomatic missions and the protection of diplomats. Fourth, to respect the sovereignty of states and their right to conduct their affairs without interference. 5. To promote respect for international law and the principle of the United Nations Charter. In Vienna Convention of Diplomatic Relations of 1961, there are several significant provisions that control how diplomatic relations between governments are conducted. Some of the few provisions are: the following are the pertinent provisions of the Vienna Convention of Diplomatic Relations of 1961. First is the establishment of diplomatic relations, which is stated in Article 2. Next, the function of diplomatic missions are stated in the Article 3. Third is the appointment of the diplomatic agents are mentioned in the Article 4. And the inviolability of diplomatic agents are stated also in Article 29. The inviolability of diplomatic premises are mentioned in the Article 22. And the exemption from taxes and duties are stated in the Article 34. The freedom of the communication are some of the pertinent provision of the Vienna Convention, which is stated in the Article 27. The immunity from jurisdiction was also stated in Article 31. The protection of premises of the missions are stated in the Article 25. And last, the protection of personal inviolability are stated in the Article 36. As what we have discussed earlier, the Vienna Convention of Diplomatic Relations was adopted in 1961 and entered into force on April 24, 1964. As of 2023, there are 193 parties to the convention and 60 state signatories. While the list of signatories and the parties to the Vienna Convention on Diplomatic Relations is available on the United Nations Treaty Collection website, which is managed by the United Nations Office of Legal Affairs. The website has a comprehensive database of all treaties and international agreements deposited with the Secretary General of the United Nations. Is the Philippines signatory to the convention? Yes, the Philippines is a signatory to the Vienna Convention on Diplomatic Relations. The country signed the convention on October 20, 1961 and ratified it on November 15, 1965 with the Senate concurrence. The Vienna Convention of Diplomatic Relations is essential to the Philippines because it creates the foundation for state-to-state diplomatic relations and specify the rights and immunities of diplomats being sent to the receiving state and the diplomatic missions. As a signatory to the convention, the Philippines has an obligation to observe and adhere to its provision, which promote friendly relations and international cooperations. The first significant legislations enacted in response to the Vienna Convention of Diplomatic Relation of 1961 is the Republic Act No. 7157 or the Philippine Foreign Service Act of 1991. It was enacted in response to the country's accession to the convention. This law, on the other hand, defines the organization and function of the Philippine Foreign Service, including the conduct of diplomatic relations and the establishment and management of the Philippine diplomatic missions abroad. This law also protect the rights and welfare of Filipino abroad workers and promote the Philippines' interest and image in the international community. Furthermore, it aims to recognize and strengthen the Philippine Foreign Service, notably the Department of Foreign Affairs. The second significant legislation is the Republic Act No. 75, which finalized the act that would impair the proper observance by the Republic and inhabitants of the Philippines of the immunities, rights, and privileges of duly accredited foreign diplomatic and consular agents in the Philippines. The person who falsely declared himself and act as a diplomatic consular or any other official international representative will be punished through this legislation. The Vienna Convention of Diplomatic Relation of 1961 and other treaties have made an impact to the international community. This Vienna Convention has been a fundamental document in the conduct of diplomacy. It allows diplomatic representatives to carry out their task in the receiving state without constraint. Moreover, this Vienna Convention of Diplomatic Relations is important in international affairs because diplomats can ensure that the relationship between governments works well. On the other hand, the Vienna Convention of Diplomatic Relations of 1961 intended to codify the long-established customary principles governing diplomatic missions carried out by the diplomatic agents between various states. It is an international treaty that will provide the groundwork for the future diplomatic relations by ensuring that certain rights and immunities are available to everyone. Furthermore, the 1961 Vienna Convention of Diplomatic Relations attempt to protect the interests of the sending state and its national in the receiving state and vice versa within the bounds permitted by international law. It also grants various privileges and immunities to diplomats assigned to the receiving state. And the Vienna Convention governs the establishment, maintenance, and termination of diplomatic relations between independent sovereign states based on the mutual consent. However, despite of the great impact of the Vienna Convention on Diplomatic Relations of 1961 to the international community, it has criticism. First, the convention contains weak provisions that allow rogue diplomats to participate in illegal acts or even for personal benefits outside of their official duty as a diplomatic representatives. In addition, certain articles of the Vienna Convention of Diplomatic Relations are unclear, allowing for numerous interpretations and violation of the diplomats. Last, some provision of the 1961 Vienna Convention on Diplomatic Relations have become out of date as a result of the internet and social media communications. The case of Jeffrey Lee Ang, which is the petitioner versus people of the Philippines, the respondents, is an example of the issue related to the Vienna Convention of Diplomatic Relations. This case is about Jeffrey Lee Ang, the petitioner. He is an economist working with the ADB or ASEAN Development Bank. However, In the year 1994, he was charged with 2 counts of grave oral defamation for allegedly uttering defamatory statements against the fellow worker in ADB, which is Joyce Cabal. The following day, the Department of Foreign Affairs or the DFA issued an Office of Protocol and sent it to the Metropolitan Trial Court, stating that the Liang is protected by immunity from legal process under Section 45 of the agreement between the ADB and the Philippine government regarding the headquarters of the ADB in the country. According to the protocol, the petitioner Jeffrey Liang is immune from suit. Thus, the Metropolitan Trial Court judge dismissed the 2 criminal cases. After the move for reconsideration was denied, petitioner petitioned this court for review, claiming that he is entitled to immunity under the agreement and that no preliminary inquiry was conducted before the criminal proceedings were brought. The issue of this case is whether or not the petitioner Jeffrey Liang is covered by immunity from criminal suit. The courts held first, the courts cannot simply follow and accept the DFA's communication that the petitioner is immune from prosecution. The DFA's finding that a particular person is immune is simply preliminary and has no legal force. Second, immunity mentioned in Section 45 of the agreement therein is not absolute, but subject to the exemption that the act was done in official capacity. Third, slandering someone cannot be covered by the immunity agreement since our laws prohibiting committing a crime such as defamation in the form of official duties. Fourth, under the Vienna Convention of Diplomatic Relation, a diplomatic agent, assuming the petitioner is one, is immune from criminal jurisdiction of the receiving state except in the case of an action relating to any professional or commercial activity performed by diplomatic agent in the receiving state outside his official function. As previously stated, the commission of a crime is not part of official duty. Finally, in response to the allegation that no preliminary inquiry was done, suffice it to clarify that preliminary investigation is not a right in situations cognizable by the METC, such as the one at hand, because preliminary investigation is exclusively a legislative privilege. It may be used only when expressly authorized by law. The rule on criminal process states unequivocally that no preliminary inquiry is required in situations under the jurisdiction of the METC. Furthermore, the absence of preparatory inquiry does not impact the court's jurisdiction, nor it does not weaken the validity or otherwise deem the information invalid, whereof the petition is denied, so ordered. The case of Jeffrey Liang versus People of the Philippines addressed that the rights and privileges of the diplomats are not absolute. The commission of any crime is not covered by their official duty. Thus, the petitioner is not subject to the immunity or protection against criminal suit in the host state. He or she, as the diplomatic representative, is liable to the crime they committed, because a diplomat's rights and privileges are only covered their official obligation in the receiving state.